So I have to make copies. I have.
All righty, good afternoon, everybody. Call this meeting to order. Today is Thursday, April 6th at 1:07 p.m. My name is Adam Wilson. I've been serving as your moderator. And this is our fourth edition to the special meeting agenda for the ad hoc advisory committee for the Resource Conservation District. So with that, I'll move to item number 2, which is our roll call by our commission clerk.
Dan Ballridge. Here. Donald Butt.
Here.
Julia S. Camila. Absent. Darcy Cook. Here. Frank Hilliker.
Here.
Andy Lyle.
Here.
Mary Matavo.
Here.
Dave Neeson. Absent. Amy Reed.
Here.
You have a quorum with 7 present.
Thank you. And Amy, for the record, can you disclose the exception to the Brown Act that you are exercising to participate remotely, please?
Yes, I have been exposed to a contagious illness.
Perfect. Thank you so much. Thanks for protecting us all here as well. So we appreciate that. We'll move on to item number 3, which is the agenda review by the moderator. I have no changes at this time so that we can move on to item number 4, which is public comment. This is an opportunity for any member of the public to provide comments on a non-agenda topic germane to our work here on the advisory committee. Comments will be limited to 3 minutes. Can I check with our commission clerk if we have any members of the public wishing to speak?
I've received no public comments.
No live emails either. Okay, that concludes item number 4. We will move on to our business items today, which is under 5. A is the first one, which is the overview of our water audit programs. The advisory committee will review material provided by Mission RCD that illuminates descriptions of the water audit programs within San Diego County. Identifying the specifics of each program will assist this committee in developing the MOU, which we will talk later on at this meeting. I want to thank Darcy for putting this material together. I know we all kind of tasked you this and threw you into this, so we really appreciate that. But I know there was a lot of questions and concerns and maybe even some confusion on our previous discussion. And so I thought it would be helpful to get this material together, which you put together so eloquently, which will give us clarification and some definition that will help us move forward in our discussion. So perhaps maybe you want to give maybe a quick overview of some of the material that you provided and say some things to it.
Sure. First, maybe I should ask, did people get a chance to read it, and do you have questions? Because I tried to lay it out as clearly as possible. So, okay, I'll just give a high-level overview then, and if you can tell me if I'm talking too much. So basically, the RCPP program that we have through NRCS, it's hinged upon our contract with San Diego County Water Authority's Ag Water Management Program. That program has 3 different sort of discrete parts. It's the AIEP program, the Ag Irrigation Efficiency Program, that provides the initial, the pre and post evaluation that the NRCS RCPP program is based on. I know that's a lot of acronyms, and I know it gets a little tough, so please interrupt me if you need me to clarify anything. It's in that thing that I sent everybody though. So that's 2 things. The RCPP program was delayed and was to start this year. We're basically still waiting on that now. And that is a cooperative agreement with NRCS, which is not like a normal contract. And so what that provides for is for MRCD to do the essential first site visit, which is basically the AIEP evaluation. And then as part of that site visit, they get to the irrigation evaluator gets to get a look and see, is this person going to be eligible for NRCS programs? Do they have some of the criteria? And then that can start that process. And there's 8 ranking criteria for NRCS. And the way the contract is set up with MRCD, we can provide 1 through 4, depending on how we work with NRCS, and then also on 8, which is the final evaluation and so the final compilation of the program. Basically, to understand this, I think it helps to think of MRCD as sort of a force accelerator for NRCS. We're helping them both. This contract both provides technical assistance support in the view and the aspect of our our personnel. Also, money's out of this contract support NRCS efforts, and then a big chunk of the funding supports the financial assistance for the program. So I sent something else this morning, thinking that maybe we need more information for an MOU. So I don't know how many people have looked at that yet. The NRCS agreement is pretty kind of convoluted, but what I sent today, and maybe you can make copies, I don't know, or I could pass this around if you'd like, but it basically spells out that of the $368,000 awarded under this contract, which now goes through 2026, 40K is allocated for MRCD. We only get 10K a year on this. 43K, if I have that number right, is for NRCS. The remaining 200 and let's just say 84 is to support the farmer, the producers, the assistance that they get for these programs. So it's an odd kind of contract. So are there any questions on that? Trying to keep it as clear as possible.
So the area for the RCPP, maybe it called it out in your scope this morning, but I didn't see it indicated here. What area does the RCPP cover?
Okay, and by the way, I need to apologize to you for the last meeting when you held up that map. That was the first RCPP map, was what I said, but that did get included in our contract, and that's on me. So that map that you had, that was the original RCPP program from, I think it was 2017. And in the negotiations for the new program, which started before I came on, Lance started this with Jacqueline Howells. And so, and that's actually when Greater San Diego decided not to participate. So we scaled that down to the water districts that were basically within our district, and then it included a few others. My understanding is there was an agreement by Greater San Diego that we could move forward with that. And that was probably with Carlos Suarez, I don't know. But so the map now covers 6 water districts: FPAD, Waima, Vallecito, Valley Center, Rainbow, and Oceanside. So Escondido and Encinitas and someone else are no longer part of that. They were on the first contract.
But some of this area is within our district.
Correct.
Okay.
And that's why we're here. That's why we're talking about this.
So clarify.
Okay. Any other
Sure.
questions or comments?
Just the clarifying question,
Sure.
but the SD County Water Authority AWMP program covers all the participating water districts in the county.
Not all of them participate. Yes, you're right, Frank, that there's 24 member agencies for the San Diego County Water Authority, but not all of them participate on this program.
She
I think
said,
22.
she said all participating agencies.
So okay, I hope I can phrase this coherently. So not all participating water agencies or water districts in the water authority receive the added benefit of the RCPP, only the ones within.
They
that service
chose to
area.
not participate.
Okay.
Correct.
Gotcha, thank you.
And so it's just 6, those 6 that I mentioned.
Gotcha.
Anybody else?
Thank you for that.
Yeah.
Well, wait a second, real quick,
Mhm.
just to clarify, the 6 districts that you mentioned are participating in this program, but I know that Escondido has people in the AWP
That
program.
is correct.
So there's so I don't know how many water districts are part of it, but whichever ones adopted it into their
Plan.
yeah, are doing it. Like, for example, in Lakeside, we chose not to have an ag water rate because we don't have nurseries or avocado groves or orange groves that would benefit.
And I'm sorry, I didn't look up that number, so I don't know how many participating member agencies there are under AWMP. So I don't know that number.
Yeah.
Anyone else?
Let me be clear,
Yep.
AWMP covers all the participating agencies within the county water authorities area. That's a fair statement.
That's a fair statement.
Okay.
Darcy, thank you so much for putting that together and providing us a little more clarification on the program. So just real quick, check with Tammy and Erica if we have any pre-submitted or live comments to item 5A?
No public comments received.
That's just one more question. Sorry.
Go ahead.
Just out of curiosity to better understand the program. With the second bullet point under the AWMP, does the rebate come from the funds through the contract, or do water agencies pay that separate, or how does that rebate work?
So my understanding is that the County Water Authority has a grant that funds this program. And so the rebates are under that grant. I don't think the participating agencies pay part of this rebate. That part I could be wrong on. I don't see that from my
You
end.
guys don't process that.
Yeah, we
Okay.
don't process that. Good question, though. And please ask all the questions you want. I'd rather hash it out now. It is a little bit convoluted.
Amy?
Yeah, so Darcy, the participating agencies do contribute a small amount. They say how much they want to contribute. They limit it. They'll say how much they want to contribute to that. I don't know if it's 50% of the rebate or how much it is, but the participating agencies do contribute a small amount towards.
Thanks.
Mhm.
Last check. Anybody else? Okay, thanks, Darcy, again. That will conclude item 5A. We will move on to item 5B. And before we get into that, and maybe I should have did this earlier, just for the administrative record, perhaps give councils for both Greater and Mission the opportunity to introduce themselves, since I'd imagine your participation will be part of our discussion here with the next item. So,
Sure. I'm Christina Cameron with Devaney Pate Morrison Cameron. We represent Mission.
Stephen Beamer for the Greater San Diego RCD.
thank you for both being here today. Okay, we'll move on to item 5B, which is the review of the draft MOU. The advisory committee will review the draft MOU that's been authored by Greater RCD and provide feedback for the committee to consider. This will provide the additional information for each RCD to go back to the respective boards for either approval or additional or added direction. So perhaps we could pass it off to Greater to start, since you guys authored the MOU, and maybe you can kick this off and start off our discussion.
You want to talk? So Steve drafted this for us and made it very comprehensive so that we could, have this place to start with. This should cover, as we discussed, kind of all the ways of working together, and then when specific projects arise, then we would use the exhibits to include the scopes of work.
Let me just comment on a couple of things, especially for the non-lawyers. The previous MOU exemplars I looked at basically identified the parties, the scope of work, and then a termination date. So it was fairly cursory. Could lead to ambiguities, could lead to problems. Not that there were, but could. So I took and built this MOU out of a service agreement. There's no pride of authorship. It identifies the issues. I've litigated grant cases, just so you know. And the way this is built is it pushes the grant obligations down to the sub-grantees. Because when you get into this litigation, the statute holds not only the original grantee, but all sub-grantees liable for non-compliance of, I'll call them the stringent grant requirements that are imposed. So the reason the exhibits are so comprehensive is because I do not want any sub-grantees to claim, well, we didn't know what the grant said, so therefore we're not responsible. Well, one, they are, but two, if they have the grant, they're on notice. They can read it, whether they do so or not. It's there as an exhibit, and we can make sure everybody's very clear on what the requirements are with their scope of work. I have no pride of authorship. I welcome comments. So if we can draft a better document, so be it. The last thing is, my task from Dawn was to develop an MOU that deals with contracts and grants. If we want to separate them and have one model for contracts versus a model for grants, I would welcome that as well. Again, when you deal with a contract, it's good to put them on notice and say, look, you're not only responsible for the subcontract, but you're responsible for the terms and conditions of what I'll call the master or the prime contract. That way, again, if the prime contract is more onerous or stringent, they're responsible for those requirements. So that was kind of the intent of the document. Again, you're not going to hurt my feelings if you guys say, hey, let's tweak this, I'm open.
Steve, we really appreciate it. I mean, we all tasked you to do this without your presence at the last meeting. So I agree with you. I mean, I'm not the expert in any of this, but I think it's an excellent document to at least have as a starting point. And then that's ultimately what we're here for, is to have a dialogue that's open and transparent, and hopefully find some commonalities and some goals that are amenable for all three parties to contribute to this document to make it something that works for all for the long-term delivery of programs and services for the RCDs throughout this region. So the way I consider today, it's an open forum to discussion, edit freely. And as Steve indicated, nobody's going to get any hurt feelings here. So hopefully we can kind of put our heads together to kind of come up with some things that work in the long run.
You have a comment? That's fine, council.
Alex?
Yeah, thanks, Adam. I don't know if other people had comments, but I had a couple of thoughts that I wanted to share with the group. I could put them in writing too after this call. I don't know if now is the right time to do that.
Alex, why don't you start it off for us, and why don't you just make an introduction to yourself, that you're Deputy General Counsel for LAFCO, and yeah, maybe you can start off with our contributions and what your thoughts are.
Sure. Yeah, so as Adam stated, Deputy General Counsel for LAFCO, and I reviewed the agreement this morning. I thought it read well. I'm really glad that it was drafted like a template so that you can plug in the relevant information and use this repeatedly going forward. Just a couple of thoughts to consider. The first one is regarding ownership of property and work product. That's Article 7. I'm just trying to think ahead, and if this is intended to be a plug-in template, this plays on the parties to determine who's going to own the work product. I thought it might be easier if the party that is the applicant for the grant, or like so the grantee, or the party named in the contract be the one that owns the work product. I just thought as a default that might be easier, and the parties can agree to something otherwise if they want. Regarding Article 8, confidentiality, in these types of provisions, I always throw in, when it's between two public agencies, I always just throw in a disclaimer about the Public Records Act to say that we disclose, but like this confidentiality requirement is not subject to anything we have to disclose under the Public Records Act as public agencies. Article 10, the records retention and audit requirement. Probably all parties would benefit if we just clarify what the pertinent books, documents, papers, and records are. So to maybe tighten up that definition, because of course you don't want to store documents for 10 years is a very long time. You don't want to store documents for 10 years that you don't need to store. So to really hone in on what those documents are that need to be retained for that period of time.
Alex, the only issue on that is there's a 10-year statute of limitations under the statutory scheme when you litigate grants. I know it sounds like a long time. It used to be 6, now it's 10. So if you don't retain the documents, you've got nothing to defend yourself in these key TAM cases that are brought when they challenge and try to disgorge the grant money from an agency. So
Yeah.
that's the reason I picked 10. I'm not married to it, but that's the statutory statute of limitations.
That totally makes sense. I think as a public agency, the default statute of limitations is 2 years. So when I saw 10, it threw me off, but I figured there was a reason for the 10. So thanks for explaining that. And if it is going to remain 10, as like, it makes sense for statute of limitations purposes, just, we probably want to narrow down what those documents are that are going to need to be retained. So
Yeah,
we
that's
don't
great.
want to retain things we don't need to retain. Insurance, fine. Work compensation, fine. Drug-free, fine. Article 8, good faith mediation. I thought it was the transition seemed a little bit odd because on page 6, we talk about good faith mediation. And then at the top of page 7, you start talking about California labor code requirements. I thought maybe there was something missing here. One of the things I thought we would include that I didn't see in the agreement that I know Greater San Diego had raised at some point, or maybe LAFCO, we raised it, was this issue concerning who determines a default. There was some discussion about having either a third party potentially make a determination regarding what constitutes a default, and also when there is a default, providing the other party with notice and an opportunity to cure. I didn't see that in the agreement either. So, I know last time you talked about providing some kind of warning or notice to the other party saying, hey, we think you need to fix it. You need to perform X for this reason.
Yeah,
So
I
just thought
I wanted to leave that open, Alex, for discussion. I didn't want to be too presumptuous and put in a lengthy, we get to enforce this through injunctive relief.
Yeah.
The problem with arbitration these days, and again, I'll leave it to council, but it's become an industry. If we end up in arbitration, the arbitrators are charging now $6,000 to $25,000 a day for arbitration. I don't think our public agencies want to pay that kind of freight. I just did a deposit for a 4-day arbitration. My side was $21,000 just for the deposit. They had to pay $21,000. So I just think council,
It gets to be as expensive as litigation
Yeah.
almost these days.
we need to really just think that through.
Mhm.
So I left that open-ended. I didn't want to put in a bunch of language and then have everybody say, that's a non-starter.
And
So
I
I-
think with the focus on individual specific agreements, I think that most of what everybody has to do is going to be contained within the grants and so on that are the subject, that become the exhibits to whichever of these enactments we do. So where there was a very vague and cursory kind of an MOU of two entities to work together, there might be a need for something like that. But I think here the attempt is to define what everybody's role is in the agreement itself and be a little clearer.
I agree.
Yeah.
So the comments are welcomed. I just think we need to think through the remedies.
Mhm.
Under 5611, 56133, I think the parties have the right to go in and get injunctive relief, in my opinion. And we can certainly spell that out. I see a lot of contracts where you agree injunctive relief is appropriate. I just don't want to see us in costly arbitration that no one really wants at the end of the day. I don't think we'll get there, but
Mhm.
we have to think that one through.
I have a about that. I don't know how we include this legally, but I think that we would be in agreement that we want to avoid litigation at any cost, because first of all, we don't want to get to that point, and second of all, we're not set up to do that. So I don't know how we put that in an agreement, but let's make sure that's a very last option.
I mean, you can make a condition of litigation be some kind of mediation or formalized process where you sit down and have a mediated conversation. If you want to, I think this is sort of I guess this is probably the most flexible of provisions, which is that everybody agrees that they will talk to each other in good faith before they move to whatever a next step is. You could spell it out further, but everything you spell out further becomes something now you have to do. And so that can also add costs as well. So
A lot of real estate contracts mandate mediation before you go to any other level. And if you don't mediate, you can't get your attorney's fees. I'm sure you've seen that before.
Mhm.
So you could motivate people that they have to mediate before they go to Superior Court, arbitration,
Mhm.
other remedies. And I would suggest that we have a working relationship and want to preserve it. I just don't think you want either party running into Superior Court immediately and starting to spend a lot of money on both sides.
How have you seen that work out in your past experience, this provision of let's work in good faith before litigation? Or is it, sometimes I anticipate if things are going in a bad way, like you've already past that point of where the tables want to, the parties want to come together. And have you seen that work out?
I
That's
mean,
why we're here.
I've seen it in
Yeah,
construction
but-
contracts work as a precondition to litigation. In putting mediation in there, one thing that you do bring to the table is a neutral that's less formal than arbitration, which can be very expensive and results in a binding finding. But a mediator at least potentially, brings somebody who's a neutral, who doesn't have a stake in it, to the conversation. So if good faith talking to each other face to face doesn't work, that would be sort of the next step. But it still is not binding and not as expensive. I mean, mediation does still have some costs associated with it. I mean, a full day mediation is going to run you, what, $5,000, something like that, typically in this area. But it's another speed bump before everybody goes running to Superior Court.
Sometimes it's just miscommunication with the
Mhm.
parties. And it's good to get the lawyers and the mediator involved, because the mediator will come in and go, well, did you talk about this? Did you discuss
Mhm.
this? You have a shortcoming here, they have a shortcoming there. It educates both sides. So sometimes it is productive.
Okay, yeah, because I mean, right now when everyone's at the table, you see that in there, you're like, yeah, that makes sense. I'm just wondering if it ever works out in real life.
I think just good faith negotiation is less. No, I mean, when it's just the parties will talk to each other in good faith, I've seen that be less effective. I've seen mediation where there's another person in the room guiding the conversation be effective, and maybe educate both parties about maybe a simple thing that they can do to resolve the conflict. Sorry, I didn't interrupt you.
No, I've seen the same thing happen in real estate deals and other,
Mhm.
employment issues, that having that mediator basically is, I'm going to use it, paraphrase something. This might be, but it's like going to a counselor, and the counselor listens to both sides and sort of gets people to see some commonality. To me, mediation's been successful in the stuff that I've dealt with. It's nice when the third party, those stakes involved, said, basically, do you hear what you're saying? Do you understand what they're saying? And, walks us through, because you're right, the good faith works fine, but if for some reason it doesn't, you have somebody with a voice of reason.
Ju- Just for clarity though, can I go back to Alex's question, is who determines the default here? We're talking about a negotiation when there's an issue, but if one party's saying, hey, we're not in violation, and the other one's saying, yes, you are, how do we get to that good faith effort of talking? Who's going to determine that fault? Is it just a strict notice from one agency to another? Is it, I know we threw out, the executive officer at LAFCO maybe making that determination? Can you help me understand that more?
I'm not comfortable with
Yeah,
that
I'm
legally.
not either. I wouldn't recommend it to.
I think you need to be in front of a judge or some person who knows the law. And I just think you need that. Otherwise you could get a result that doesn't serve anybody's purpose.
So what happens when there's a party that says you guys are in violation, the other party's in violation, and the other party says, no, we're not?
Well, then,
When you sit down and talk about it first and try to walk through it, and then if you can't come to a reasonable thing between the two parties, then go before the judge, but first try to handle it internally.
Well, then, follow the process, good
Right.
faith, we would sit down.
Yeah.
We would sit down and say,
Right.
hey, I think that wasn't right. Yes, it was right. Okay. Now the next step is we can't come to agreement. Let's bring the mediator in
right, right.
and let's have them walk us through it. And they may say, hey.
Right.
And the mediator is going to also have the ability to pull in some expert testimony or
Right,
expert
right.
folks to help them guide them. And if we still are at that spot, then we go to the injunctive relief and the legal.
But I mean,
process.
the legal remedies exist whether you put them in the contract or not. If LAFCO decides that they see something that is wrong, they're not a party to this contract anyway. They can bring whatever action they want to. So those remedies aren't changed by what we write in this agreement.
Gotcha. Alex, do you have more?
Yeah, I just want to say, I think, based on this discussion, it would probably be to everyone's benefit to have some kind of requirement in here that says when a party determines that there's been a default, then they have to issue a notice of default to all other parties. And then there has to be some kind of cure period. I think that's probably something reasonable to include in the agreement. With respect to LAFCO's EO's role, I thought about it in a more limited context. I didn't think the EO would make determinations regarding defaults under the terms of this agreement. I thought more like the parties agree that any determinations regarding a 56133 violation will be determined by the LAFCO EO, because that is within LAFCO's purview. And I thought it narrows the scope of things that LAFCO would consider, because LAFCO frankly doesn't want to be the mediator of this agreement. But with respect to 56133 issues, no, that is within LAFCO's purview. They're going to weigh in at some point. So I thought it might be helpful if the agreement itself says there's a 56133 issue that arises, LAFCO EO is going to make that determination for the parties. Just a thought. It's up to you folks how you want to draft it.
I don't think that MRCD wants to contractually agree to something that isn't in the statute, particularly something that was suggested to be added to the statute that was ultimately not added. I guess.
The problem with that is, how does LAFCO then enforce if the executive director has made a decision? Because LAFCO has the ability to enforce, obviously.
Right. So there's,
I think it puts them in a dual role and puts
well, I
them
think
in a
it creates a due process
conflict
issue.
and a due
potentially.
process
Yeah.
issue as well.
Well, that's how we got to where we're at. I mean, the reality
That's
is, we felt there was intrusion on our area. We went to LAFCO. LAFCO said, hold on, we'll do an MSR. Eventually they got to the MSR, and the MSR created a special study and this ad hoc group. No offense, but I didn't see that process effective. That's why we're here. And that's why I think an MOU that sort of lays out our relationship
Right.
and then doesn't include LAFCO, because like you said, LAFCO still has an obligation. If any one of the parties feel that we're not getting a resolution through our process, nothing stops us to going to LAFCO and filing that complaint with LAFCO.
That's, yeah.
And
I think there's just a separation of powers issue that we muddy by,
Yes.
because you can contractually do things that go beyond statute, but that's not a position where MRCD wants to be at this point.
Would you agree that we would have the right for injunctive relief, both parties?
I don't know, but if it's already statutory, as you already stated, then I don't know why that doesn't exist, whether we put it in the agreement or not.
I think it's under CCP 526 is what
Mhm.
the injunctive relief.
Right. But I mean, if that is a remedy that exists ambiently,
Right.
then I don't know why we would put it in the agreement. I mean, if there's some ambiguity and there's some rationale behind putting it in the agreement to avoid that kind of an issue later, I would, you know.
Yeah, and a lot of non-competes, you see the parties agreeing that a violation does give rise to injunctive relief, and all it prohibits, again, these are just talking points.
Yeah.
It prohibits one party from saying, yes, injunctive relief applies, and then the other party says, no,
Mhm.
it's not under 526. And then you have this battle over whether or not you can go into court and get a TRO or a preliminary
Right.
injunction, et cetera. I'm sure going forward, each party is very much aware we shouldn't be violating boundaries without consent and LAFCO
Mhm.
approval. So just think about that.
Yeah, let me, I mean, I don't want to say absolutely not. Let me take a closer look at
Yeah.
that.
That's great.
Could you clarify for me what injunctive relief is?
So what happens with injunctive relief, and obviously your counsel can let you know as well, but it's a remedy to preserve the status quo. So let's just say Greater San Diego went into your district and started doing work.
Mhm.
You objected. We said, we're going to keep doing it. You can go to the court immediately and get relief in short order within 24 hours. And the court can say, look, this is a violation. You shall refrain from doing work in the other governmental entities' boundaries. Then that lasts for 15 days. And then you go in and get what's called a preliminary injunction, which stays that for the remainder of the case. And then ultimately you go to trial. It's just a more adequate remedy. Sometimes
quick.
Yeah.
it's quick and protects the parties versus waiting. These cases now are taking 18 months to 2 years
Mhm.
to
Now-
get to trial.
As I was looking through the agreement, it seemed focused agreement by agreement, even though there's a baseline structure for how you're all going to work together in all the geographic areas. It really isn't effective unless a particular contract for a particular kind of work is attached to the agreement, or it gets an addendum to it.
That's right.
So I'm not sure where, injunctive relief really is a viable sort of option in that context. If we had a big agreement that said, we're going to do a lot of things together and, and we're going to work together to do those, but it wasn't particular agreement by agreement, then I would understand that. But it seems to me that this is pretty narrow. The only thing we have protection from each other in each other's districts is to the extent we attach to this individual specific work projects.
Agreed.
So,
I didn't think we wanted some master agreement.
yeah, and I guess I thought I wasn't sure.
That
'cause
was my
I thought it was
question,
kind
too.
of going to be a master agreement. But I also felt that each agreement would still have to be addended to it in order for it to be performed.
I think that's what we agreed on last time.
That's what,
Yeah, that we would have a master sort of
That's-
terms and conditions, if you will, and then for each project. that
Those are
was
exhibits or
intersect-
something.
Yeah,
Yeah,
Or addendum.
which I think is,
You could turn this into a master.
Yeah,
agreement. It's
but I
not a
think
problem.
even so, I think even a master agreement still only is effective as to those work plans that you all ultimately agree to attach to it.
Was-
So,
Would it be easier to just use a template and then just have each agreement, do each agreement, but just kind of have it follow the same template?
yeah, I think that's the plan. So when we say a master, right, that provides, you don't have to negotiate any of the basic terms and conditions. We just throw in the new attachments and everything in here refers to those
I'm
attachments.
talking about one like on its own. That way it's clear.
So there's a difference between I'm hearing a template that we use
for each
for
agreement.
each project
Mhm.
or each grant or contract. And then a master that is a global document. And then as under inserted would be Appendix A, Appendix B, as those projects, we simply just add an appendix to that.
But that's how this is set up.
I think that is how
It
this
is,
is
yeah.
generally set up.
It is.
And I think that there's things you're gonna have to sort out with each contract.
Mhm.
Because who
They are
does
gonna
the
change.
work in each type of contract
Mhm.
may look a little different. Who manages who's the project manager, which agency is the project manager of an individual grant may change from
Mhm.
project to project, grant to grant.
And that would be covered, my vision was that would be covered in the exhibit.
Mhm.
So
I think you're right. I think
You
it
know,
really does have to be.
the
in
scope of
exhibit.
work, the original document,
Correct. the
the
original.
grant or the original contract becomes a master, and then the scope of work and the relationship is built into that as well. So there'd be a master agreement,
Mhm.
then each project would have the principal document with the grantor or grantee,
Mhm.
and then there'd be the sub-grantee contract, and that would lay out all the terms and conditions that we would expect for that process. And again, who's the lead, who's secondary, who's
Mhm.
taking what their administrative costs are, what the rate of pay is for whatever the project is,
Mhm.
anything that would be
Right, right.
addressed by the financials out of the primary document.
I have a question on timing, not to move away from this if you're not done about injunctive relief. But how does this work when there's an RFP? So
That's what
I
I was-
sent you
that
that
was
San
gonna be
Diego
one of my
County
questions.
large landscape RFP. That's a 3-week turnaround. So how does this work when we say we want to go and respond to that? How do we work out something quickly that allows me to do that? Or, normally we could just have a conversation and say, well, do you want to respond? Yeah, well, no, maybe I'll team with you or whatever.
I don't see it changing. If anything, that still stays in place. This is coming up. Do you have the bandwidth? Yes, we do. Here's what we can do. You know what? We don't have the bandwidth. Run with it. We'll support you. We don't have the staff, but that needs to be worked out as part of your submittal. So that way, for example, when whoever submits shows the partners in that and we're listed, that's the vision I have for this process is I'm not going ahead and coming back and say, hey, guess what? I want you guys to join the team.
Mhm.
I would like to say, hey, this opportunity is coming up. What do you want to do on this project? Or what are you comfortable doing? Or what are you able to do? And then let's develop that scope of work and let's submit it together. Now that may mean together, we're the lead, we're going to take it, but we need to know what your inputs are. And that becomes the document that we use to back this up.
Mhm.
Because we put out a lot of work towards grants and, just like anybody else.
Right.
We get lucky and we get them, but there's a lot of times we don't get anything. So I wouldn't want to put it attached to this until it gets granted. Then when it gets granted, we
Okay,
further
good.
work out those details and that become, the preliminary documents become the
Right.
documents I talked about, which is,
Okay. So just one more question.
Yeah.
So for example, let's just use the large landscape one. That's a very big contract. It's way bigger and out of the scope of what Mission would do. I would assume it's kind of the same for you, but I don't know. But there's a part of it that I would like to respond to with one of the many interested parties, the bigger landscape companies. But so how would that work short term? Would you have to take that to your board to get approval for cooperation? Or once we get through this mess, can we just sort of have a normalized relationship on that?
I was going to ask you, Steve, it seemed to me that the only place where misunderstandings could arise could be before you have a grant in hand.
Yeah.
How do we memorialize an agreement that it's okay for you to submit for an RFP or them to submit for an
Or
RFP
partner.
that falls within this framework? So that we don't end up at the end of the day with, you going, you know what, that, I don't really think that works out so well. No, it's a no. And now somebody has to go back to an RFP that they submitted and say, sorry, we're out. So I don't know if you have any thoughts on that, Stephen, on how
I
we
think
would.
you'd have to actually enter into the contract subject to getting the RFP. Because it's probably some RFPs you can't back out of.
Yeah,
You're committed.
so that's what I mean is we
I
have
mean,
to sort of,
once you proposed, you're
Correct.
saying, okay, yeah. Mhm.
So if your partner, I represent a lot of contractors. They call their subs all the time and they say, hey, I need your bid, I need your proposal. They do governmental jobs, they get the job. The sub has no luxury of backing out.
Yeah, if it's a government.
There needs to
money,
be, if
yeah.
you get a contract and you need our assistance
Mhm.
and then we pull out, it could put you in jeopardy because you can't perform.
Mhm, mhm.
I'm aware of that and concerned about that. So I
That's
think
at
we
a
could work
higher
together and
level.
make
That's what I was
sure
thinking,
we
yes.
can deal with that issue.
Yeah, that's a higher level than we typically work at. We can usually work out an MOU. I mean, I work out a mod or something, but no, I understand what you're saying. It should be thought about.
I'll put that on my list.
And I had a number of, I have a number of things that I think are really kind of clarifying in places where it seemed to me that there were issues that probably are on the order of something that Steve and I can work out. Like, one of the things was that there was a 30-day termination provision, and that worried me because it seems to me that's fine. You can, within 30 days, decide, I don't want to be doing this anymore in the future, but there has to be a provision that says, however, you can decide not to do more things in the future, but whatever you've agreed to participate in and work together on, it's 3-year agreement or whatever, we can't
Right.
yank out of those kinds of things. So,
Great. These are just talking points.
yeah, yeah.
And the reason the prevailing wages in there is you have to put sub-grantees and subcontractors on
Ask about
notice
Mhm.
that it may be prevailing wage. Then you
Mhm.
shift the burden to figure out prevailing wage downstream. If you don't do that, then the sub-grantees and or subcontractors, they're not, and they don't pay
Mhm.
prevailing wage, you're on the hook
Mhm.
as an entity if you don't
Right.
put them on
If
notice.
they mess it up.
So it may not even be applicable is my point, but you still have to put them on notice.
Is that the same with the drug-free workplace certification? Is that
It
follow
is.
the same model?
It-
Okay.
It is. I put that in for that reason as well.
That's relevant.
It comes out of all the grants
Mhm.
right on
and
the
it
federal
pushes it down under the federal scheme.
But doesn't the incorporation by reference take care of that? That was going to be my question. Because it's going to be in whatever grant is the
Mm.
attachment, so.
I mean, we could do it that way. Again, when you put your sub-grantees on notice expressly,
Upfront.
they
rather
have
than
nothing
in
to
the
argue
exhibits.
about. So it's up to you guys. You could streamline this a little bit and I have no problem. Again, I wanted all the issues on the table.
Thank you for that. I appreciate that.
And I'm happy to I wrote these comments and made revisions that were really just for talking points for here. Again, for me, no pride of authorship. I really wasn't, I have 6 copies. I'm happy to give it out as many as you want. And I can email Adam another one so you can distribute it. And these are not necessarily all things these are not go to the mat issues. These were things that as I looked through, I thought, I don't really understand that provision exactly or how it works. So. But maybe it makes sense for Steve and I to go through and do kind of a page turn on this
That'd be great.
after we get
Yeah.
notes from everybody here.
And Darcy, you bring up a good point, and that's something that maybe we should incorporate into here, is,
That's what I want to get back to.
yeah,
The
how do,
process for
how do
That's why
we,
we're here.
how do we partner on this going forward? And maybe there needs to be some sort of language, and this is for you guys to think about, but how do we lay the framework that
Right.
we commit when we move forward? Because no different than, all three of the districts have to get approval for their boards to move forward on this. Maybe one of the things, and I'm just throwing out there, that if it, once it's submitted, it's binding if it's accepted, that maybe that might be a way to separate that stuff, because there's a lot of stuff that we're throwing proposals, and lots of times the grant, they accept your proposal, not formalize it. And that's a different arena than submitting, like I know a lot of the firework we do. Once we submit, if they accept it, they're expecting us to do it to that scope and that parameter. So it's a real tight margin all the way around. And you bring up a good point. I just think maybe that's something that the attorneys can work on, crafting something into that sort of sets the stage for partnering and what that partnering looks like before the contract's signed.
Do you guys always, and this what would help us out, maybe you already know this, Steve, but do you always need to go to your board before you submit an RFP? Both of you?
I mean, before submitting a proposal?
Yeah.
No, I mean, I generally let my board know
Right.
that this is coming up, and I think it's under a certain dollar value.
Okay.
And, so it's not an agendized item, it's usually just part
Right.
of my
I just
report.
think we need to, whatever we do, we have to make sure we're not incompatible with any of your requirements.
Well, and that might be an opportunity for us to put our policies into alignment, because that's part of the partnership. So if there is a up to I'm just gonna throw a number out, up to $1 million grant that we can give our executive director the authority to move forward with it, if that's what we all three as districts, that's a margin that works for us. And if anything above that, that creates, if there's a liability, and again, Steve's reviews all of our contracts, he'll have a better idea on that, but
Use the contract or the proposal.
he reviews the contracts when they come back in.
That's where we need board approval, is to sign the contract.
Right.
I guess you have to talk through how you do it pragmatically. I can't imagine a multi-million-dollar grant and not knowing who your partners are gonna be, or your
Most of our grants-
subcontractors to get it done.
Unfortunately.
You just get dozens of those every year.
Which one do I want?
Well, and maybe it is a dollar amount, but up to a certain amount, the executive directors will confer and,
I think we
agree.
have that in our policy, I just don't know at that level.
yeah, no, that's fine. Maybe the two of you can, and then do we have, have we got that kind of information from San Luis Rey? I noticed that they're a party to this. Down our- sorry, I don't know the parties
Amy, you still there?
as well as-
I don't see you're on.
Okay. But that's somebody else we should, maybe one of you can
Do you
reach out
guys,
to her.
as a board member, do you recall if there's any limits that,
I don't know, in the policies.
yeah, it's in the policy somewhere, yeah.
I think what would be helpful is for each agency to kind of let us know what the guardrails are on each of your agencies in terms of your staff level authority versus board authority. That way that'll help Steve and I kind of craft something.
We're
And
happy to
then maybe
normalize
if
that.
you can, even if you can kind of lay out and sort of like a just point by point, if it was just, everybody was just kind of sitting around a table and figuring out how to do this, what would be the steps? I think that would help as well.
Mean steps as far as board approval and
Steps as far as what would you, if you wanted to sit down and partner and we didn't have the constraints of all that we're sort of working within right now, how would you just sit down at the table? What would you do? Whose approval would be necessary to say, submit, and then what needs to
Yeah.
happen after in order to accept and so on?
Because normally I would just call you and say, hey, we're gonna respond to this,
Mhm.
because things are usually pretty quick and we're all busy.
I think that would definitely help us. If we sort of laid, that would be a good working document for staff to know, okay, here's the flow chart for
Yeah.
the step-by-step process for developing a joint grant.
Right,
You know,
right.
Yeah,
as opposed to us always doing something one-off. And at least we know, maybe that's part of this document.
That's what I'm thinking, is if it spells out kind of, what's gonna happen before pre-submittal and so on, I think that might be helpful.
and keep it simple. Yeah,
We'll,
we're always just.
we'll do our best not to legalize it up, right?
Yeah, I think the pre-submittal is very important that you guys are all on the same page before you guys even get on the railroad track of
Mhm.
any type of process.
You want to ask Amy that question?
Amy?
Hello.
Hey there.
So you guys were cutting out, so I didn't get the whole part of the last sentence.
Do you have any financial thresholds in your policies that trigger your ability to go seek proposals or an RFP, or do you need board approval over a certain amount?
I need board approval over a certain amount. I want to say it's for the RCD is $30,000, but I could be wrong on that, but I do need to seek board approval over a certain amount.
Is that to respond, submit, or to put out an RFP?
Well, you have to seek board approval. The board has to approve the RFP to go out to begin with. And then to enter into a contract and issue any sort of a purchase order. The threshold is, I believe, 30,000.
But that's when you're seeking services to the agency, right?
Yes.
To RCD? Okay, so do you require board approval when you are going to answer up to an RFP of another entity?
Honestly, I don't know that that's ever occurred, so I can't answer that question intelligently.
That's fine. Yeah, I mean, it's just,
Yeah.
we're just trying to
Well,
see
yeah,
where the guardrails
Yes,
are.
that was the
on this.
topic what we were discussing, Amy. I
Yeah.
think Christina, you mentioned is maybe you guys all go back and look at those individual guardrails of what your policies and your limitations are, and
Mhm.
we can consolidate that and kind of then go from there on what
I
those numbers would be.
Right. So basically, the whole point of having my board approve anything is if we're going to, create a liability or a debt for the district. And so, I guess, why would I bring an RFP approval to my board if it's for another agency to do?
Well, let's turn it into grants, because that's probably more applicable. To submit for a grant, if DOC, Department of Conservation of the state had a grant opportunity, what sort of clearance do all three of the executive directors need to submit? I mean,
There is clearance. I just don't remember what that.
right,
number
but
is. Yeah.
there's a threshold you
There's
have.
That's what we
Definitely
kind of need to
Right.
figure out. I mean, frequently it has to do with when there's a matching obligation.
Right.
Obviously that's going to commit funds of your entity,
Right.
or gets to say yay or nay. It's a budget issue.
Sounds like
Right. And it would
homework.
Work, yeah.
typically, historically, it's any grant opportunity, the board would give the, authority to go ahead and apply for that grant. There hasn't been a dollar amount threshold associated with that. But it would, again, if it's in any liability that would be created for the district, would have to have board approval above, I want to say it's 30,000, but please don't quote me on that.
I have a question, Steve. You brought up, what do I say? You discriminated between grants and contracts. Once I have a contract, I just consider them contracts. What is the legal distinction here? Can you help me with that?
Certainly, grants typically come from the federal government or the state.
Mhm.
Once the grant is issued, the grantee has stringent requirements to comply to the letter with that grant.
Mhm.
You can't decide between the parties, your subgrantees and you, if you're going to vary from that grant.
Hmm.
Otherwise, the monies can be clawed back if someone makes it an issue. So grants are very stringent. With contracts, you have a little more flexibility because you can renegotiate
Mhm.
and amend a contract.
Mhm.
So you've got two very different animals at work
Mhm.
here.
Mhm.
And then you can be audited under your grants.
Mhm.
So the federal government or the state, they can send out an audit team and actually audit your grants for compliance.
Mhm.
So typically under contracts, they don't do that. So you don't see that in a contract setting.
Okay,
So it's just a stringency requirement.
okay, no, thank you for that.
Federal grants over 750,000 require single source audit, I think it's called. So they actually come in and do a laser focus on all the federal money. So it could be multiple grants. If you receive more than $750,000 in federal grant money, that triggers above and beyond your annual audit, it triggers an audit just of those records.
Yeah, I used to support contracts in another lifetime and we've gone through audits, but I was just curious about that. So
Right.
but we have a USDA grant and we were allowed to make modifications to that. We had to work with the contracting entity and
The grantor,
yes,
of
And-
course, yeah.
yeah, but sometimes there is flexibility. I-
Sure,
I
if the
suppose,
grantor
like when we're
agrees.
talking some of these other entities, even with DOD, doesn't matter, that's quibbling. Thank you.
But I think one of the things that occurred to me as I was reading through this is that, and I think somebody already sort of began to touch on it, was that it might be good to have a lead for each of the grants or contracts. And the lead would seem to be the applicant, because you're going to need a place where that,
Right.
you know, where that
You need to
grantor
find,
can go to find those records and so on.
Yeah.
And it just seems like that would be an easy way to track who's going to be that lead, if you will, for that particular contract.
And I think your comment, your part on bookkeeping was very relevant. It seemed like maybe it doesn't have to be spelled out because we probably all have slightly different ways of doing that. But I think the general concept that we need to keep good records, I mean, we have to do that anyway. The transparency, the record keeping, the time length for keeping documents, all of that. So,
And that was more for these sub-grantees. Let's say we're the lead on one. You don't maintain your records, we get audited, we call you up.
No, I.
Where are
agree.
the records?
Right, right.
And then I think the audit, our ability to look at the narrow scope of documents that apply to the grant is important and vice versa.
Mhm.
That way, we have the ability to make sure there is compliance
Mhm.
at any level and it's transparent. And you'll see as an exhibit, I asked that we append our boundaries so there's no guesswork. Or we could share it on a more informal basis, but everybody agrees, here's the boundaries. So if you're going to go into our territory or we're going to go into yours, we need to have the collaborative approach and then consent of LAFCO. So there's no guesswork again on boundaries.
Mhm.
This thing needs to be, obviously the MOU needs to be refined. We've got 3 lawyers, we can get there,
Yeah.
but we need to get you a work product that works for you, what I'll call in the field, and not technical with a bunch of legalese. You need to be able to work with the document.
Thank you, to be able to understand it.
And just so I'm clear, not to regurgitate, but are we all in agreement that this is serving as a master overarching type of MOU that sets the guardrails and the frameworks of how you guys deliver your programs and services? And then with each grant or contract, it's inserted as some sort of addendum or exhibit that
We
is
just
kind
need
of
to
like a
change
living
the language.
document.
We
We
can,
just
we can convert
tweak it a
this.
I just
little.
want for the record that we're all in agreement that that's the direction that we're going in.
Yes.
Okay.
We can make that work.
Yeah.
Yeah.
No, I don't see- I do think we should include, because Darcy brought up a good point, we do need to include the
Yeah,
Yeah.
absolutely.
Pre-submittal.
Yeah.
and the pre-submittal
Mhm.
discussion. Part of that is, okay, boundaries, part of that is, responsibilities, who's the lead, all these
Right,
things.
And I think what the master agreement gives is sort of the framework for how that's going to happen. And then the addendums become, the formalization of each of the individual grants that you all jointly apply for, or concede that it's fine for them to do a little bit in your area because you don't want to or whatever.
And again, I actually think we do it jointly. And let me share, because it's in our area, and going back to the government code and what brought us here is, now we have an agreement that, yes, it's a joint, you're the lead.
Mhm.
You may be doing the work in our area because we don't have the staff, or we're focusing energies, whatever. But I still think it should be a joint application.
I think, yeah, go ahead, sorry.
No, I'm just saying in name, if anything in name only, if you're taking the lead and going to carry all the
I
water,
mean, that harmonizes more partnership as well too. when you
yeah,
do
that's what I'm
that.
going with. Yeah.
I agree. I just want to be careful because some contracts or don't want to have multiple applicants. They want some kind of a single applicant. And so if we're not going to create like a JPA that is, you know what I mean?
No, I'm not saying create a JPA. I'm
Right,
just
right.
simply saying that in there, we put some language in the submittal that, Mission will be the lead agency and partnership or in cooperation with and in accordance with understanding Government Code 56133 and referencing this agreement in accordance with it, whatever we call this agreement, the global
I
agreement.
think in describing, whenever you describe who the applicant is, you can do that. I don't know that we're creating an entity
No.
that has the power to respond to certain kinds of grants by just entering an MOU.
No.
By entering the MOU, we solve the problem of 56133.
Right.
Essentially, is what we do. But I think we just need to be careful because we're not creating an entity that you can go look up on the Secretary of State's website, so may not be eligible. To be
No,
an
and I'm not
applicant.
saying, I
Yeah.
just think we need to reference the MOU
Yeah, I agree. Yeah,
as,
yeah.
as the authority. So because, for example, NRCS does this all the time, and I've got they give regional grants out to RCDs that cover other RCDs, but never make a provision or ask that,
Mhm.
has that passed the LAFCO test? Because only, I guess, the state of California are their LAFCOs, because everywhere else they work, they say, well, we've never encountered
Like,
this.
we don't care.
Oh,
Yeah.
is
Let
that
somebody do the
why?
work.
Yeah,
Oh.
I guess
So we
LAFCO.
actually pay attention.
Yeah,
At our,
yes, you do.
no, but I think that description is necessary in that
Yeah.
application because it gives the coverage to not just LAFCO, but whether it's the water authority or whoever that
Right.
has that coverage
And I
to
think it
show that you guys are in
Yeah.
agreement to that.
signals to any potential key Tom litigant that we've covered the issue, I suppose.
It's always your disgruntled employee. It brings you key time cases. So
Yeah, that's Nathan Fletcher.
what I envision is if you're the lead, you're the applicant, you will have said, we're going to be the sub-grantee on this scope of work. It's appended.
Mhm.
It's that
Right,
simple.
right. Pursuant to.
You get the
agreement.
RFP, we're the sub-grantee on that scope of work, and then
Yeah.
vice versa. We're the
Right.
lead.
They're the sub-grantee.
Or even if it doesn't include a sub-grant. So for example, let's just use the San Diego County large landscape thing. If we were to work with another entity on that, we could say, in agreement with Greater San Diego, we can do this work throughout the county. Well, probably it'd have to be an agreement with both our CDs. So it wouldn't be a subcontracting relationship per se. It would just be an agreement that we were providing services that the two of you weren't interested in doing. Does that work?
Sure, we just need consent from LAFCO for you to come into our district.
Well, I don't think
Well,
you need
you don't
consent
need
as
to
long
have
as you,
consent
as long
from
as you
the-
have this and you addend it to this, the
Yes.
particular grant.
Agreed.
Yeah,
So LAFCO needs to approve this.
that's what I'm trying
Yeah.
to, my
Yeah.
goal would be LAFCO approves just the,
Yeah.
the
Framework.
framework
MOU, yeah,
agreement.
Mhm.
And every time we have a grant, I don't want to be running to
No, no,
LAFCO every
Yeah.
time on
No,
these
agreed.
3-week turnarounds. So,
I think the goal here is to have LAFCO or the
this.
commission approve this master MOU. This is your guys' rules and regulations to
right.
your playing field, and then you guys,
exactly. And
you
then we
know,
just keep going.
yeah.
And if it's attached to that, by default, it's approved by LAFCO. Because they've
Correct, yeah.
approved the master
Exactly.
agreement.
Yeah.
Right, right.
And we've agreed and they've agreed.
Yeah,
and we're
all the
done.
parties,
Yeah.
are all three parties.
Because the only way that you could, yeah, I guess, but I would assume that LAFCO does not need to be a party to this.
I think I have a consent, don't I have consent?
There was just a phrase within the recitals that said, and within the limitations of the authority's resources established, blah, 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 blah,
Yeah,
but not
written
limited to
consent.
compliance with Government Code Section 56133, written consent as follows. See, this is what I worried me about that last recital was, it's, the way I read that, it might read as though every time there's a
Yeah.
new addendum, we got to go back to
Yeah, well, let's just
LAFCO. and
clean
that
that up.
seems-
We do need to get
Yeah.
LAFCO's consent on the master agreement.
Yeah.
Yeah, but I mean, I just think once we do that for administrative efficiency, we should try to craft it such that we can then just, within this confines of the agreement, continue to do what we want to do.
That's
Alex,
great.
are you in agreement to that or anything to the contrary?
No, totally agree, and LAFCO doesn't need to be a party.
Okay, thank you.
Can I just ask, maybe this is procedural and it doesn't need to be part of the MOU, but in the case where, like, let's go back to this large landscape one, if the mission wants to apply, but the two other RCDs don't have the capacity or skill to do that, and we decide that we are not going to, and mission will deliver it across the whole county, what approvals do we need? Like, does our board need, do our respective boards need to agree to that?
Probably, so
formally in
there's
a board
no,
meeting?
so there's no miscommunication and we don't get back to where we were. I would think that would need to be bumped up to the board, whether it's agendized or just discussed.
How quick are the large land, those kinds of opportunities?
That sounds
Well,
like such a crunch.
that's
That's
just
what I
about 3
worry about,
weeks. So, yeah, so you're right. If you, but I don't know, how does the board feel about that? Who else from our board members? So,
I would say, I need to run that past the board to get, I don't have a good feeling.
Wouldn't that be for every respective RCD?
Yeah,
Because you guys may feel differently on who gets that authorization.
right, yeah. Well, it's not on the RCD. I think it's just a matter on the scope of work and what it is. Because, I'm not in a position, I couldn't speak on the temperature of the board with regards to that.
Mhm.
You bring up a good point, but that's going to slow down. I mean, I'm putting on my administrator hat now, my day job. If I have to go back to my fire board every time something, yeah, that's going to cause, that's going to slow down the process. And we're going to miss windows of opportunity.
Mhm.
So how do we, but there's going to be stuff that I know in particular, some of my board members want to know what's going on and what's going on in our backyard.
And maybe it's like a update at a board meeting versus an approval. I mean, is it's a staff issue versus a,
it's the timing.
Yeah.
Yeah, because if you have a,
Can I ask a question?
that you have to.
When the RFP is issued, is it, and you put an RFP in, is it mandatory? If you get it, you have to accept it?
Accept an RFP?
Right.
No.
So you could always reject it?
Oh, yeah, you don't have to, so an RFP is just a request for funding, it's got
Right.
100 different names.
But
now.
I'm saying the governmental agency says, yes, we're going to award it to you. Are you required to accept that? Because like in a contractor that does a public works project,
Uh-huh.
they have to post a bidder's bond, and if they don't accept the RFP,
Mhm.
they forfeit
Oh,
their bidder's
yeah.
bond, and there's a
Yeah, just-
No, we
ramification.
don't have that.
Yeah, because these aren't construction contracts.
So they
It's
could
not
be
the same kind of
subject
bidders.
to ratification by our board.
Yeah, that's a much different thing.
Okay,
So-
but I'm saying the two
The
agencies. should-
solution, I see where you're going with the solution might be, is that the boards would ratify.
Ultimately ratify the executive directors say,
Mhm.
we're gonna
Mhm.
tackle this, then it's subject to
It gives you-
ratification by both boards, and it gives an out if either board backs away.
So
Right.
maybe in something like that, it becomes, we want to set some kind of a threshold where essentially the executive directors will confer with each other. That will create a, I guess, a preliminary approval, but it's still subject to board approval before the applying entity could accept the contract.
And wouldn't that just line up with the thresholds that we're talking about too?
What-
Mhm.
Well, how does this work? And I don't, did I interrupt you? How would it work? So let's just use this large landscape one. If we turn around, Ann and I talk, we decide, just for the purposes of this conversation, but you don't want to get involved, but I do, and in order to do the work, I have to do it outside of my district. If it makes sense to you and we agree, can we just append that to the board? Or just, maybe can we have a conversation with the board presidents and get basic approval, or does the
That's
whole
gonna,
board?
that's gonna vary
It's
with
just gonna,
boards.
yeah.
Every time there's a new board, that philosophy is gonna change. Every time there could be a new president, that philosophy could change, because remember, the boards are collectively operating. I can tell you, I've seen boards that want to be drilling down and are moving the threshold limit for the director's authority further down.
Yeah.
And then I've seen other boards come in and say, you know what, you've got this,
Yeah.
there's a different
Mhm.
philosophy with different boards. All it takes is an election change or a change in board members to change the
But,
philosophy.
I mean, I think that just speaks to my last comment. Doesn't
Yeah.
that align to the thresholds of what each individual policy is for your executive
Yeah.
directors? And once you guys get that big information, I mean, hopefully we're all in the same ballpark, 30, 40, $50,000. If one's 1 million and one's 10,000, then
Or
obviously,
if we don't have the
Yeah,
capacity.
yeah.
And, yeah,
so.
okay.
I have a question on what Alex said on his last comment. He said it does or does not need LAFCO approval. And was he talking about the main overall document or each?
He was talking
Like I
about
said, it
the
doesn't need to be
overarching
party,
document.
but go ahead. Alex, go ahead and clarify.
Yeah, that's right. This template is what I'm talking about, should be reviewed and approved. And then individual agreements after that don't need to be approved, but I also added that LAFCO doesn't need to be a party to this agreement. So it's just a one-time review. We like it. It makes sense under 56133 and proceed.
Thank you.
Okay, I'd like to maybe just get us going. We got about 14 minutes and
So could we go into specifics a little bit then? Because I have a contract right now, the RCPP, that we need to figure out how we're gonna work with this. And it was decided that this first MOU would probably utilize that as a statement of work. So that might be good. And then just for the purposes of the large landscape one, did you get a chance to look at that?
I haven't, I can't get into the bid net, but I'll go back and try it.
Oh, okay.
Did you have it downloaded? Did you send it to me?
Yeah, I'm sure I do.
Okay.
So I will send that to you then if you
Great.
want. So, yeah, and then what was important to see though was under BidNet, it gave a list of everybody who expressed interest.
Oh.
Because this is bigger than RCDs,
Gotcha.
but the part that we would do is task 4.C, I think it is. It's basically doing some of the water smart evaluation. So it was a
So-
way to provide additional funding to Water Smart. And since that's not really being worked out, but that would be the entire county.
so is there something out there that's unofficially could be used as a test case? Is that what I'm hearing?
Well, RCTP's first, because we really have to get, I mean, I have a contract and I need to work on it. I want to make sure I have an agreement to go forward on it.
RCC. This one here, you're
The
right.
RCPP, did I say that wrong? I'm sorry.
No, you did. I just want to make sure. Because I was in the impression this one was already in place and it's,
It is in place, and yet my understanding was you were having issues with us doing the work in the 2.5 water districts that were not in my district. Well, and that would be in yours too, but Amy indicated, I think that she was fine with that, but that's something that needs to be decided today. Well, to my mind, it needs to be decided.
my impression, my recollection was on the irrigation. The residential commercial irrigation.
No, that was the waterscape and that's gone now, that we lost that.
And I thought we said that because this ends,
The AIEP,
the RCC, I guess I'm a little confused
Me too.
because I thought we had agreed to let this one go through the system with the understanding that it was a sign of good faith that we're going to put a closure on a global agreement and we weren't going to stop the process. We would support moving forward, but we wanted a very specific scope of work
Mhm.
and understanding of the parameters, the location, we want more than just a one-page description of the program.
that's what I provided
Okay,
today, and I
right,
can give
but-
that to you right now if you'd like to take a look at that.
Well,
You have it in the email.
okay.
And so this was.
Again, I've been in meetings all morning. I haven't had a chance to
That same,
look
I
at this.
understand. That's why I didn't get it out till today. That should be.
So is
within-
this the one that's coming at the end of June?
No.
Okay, so I know this is complicated. So we currently have 2 contracts. One is for the San Diego County Water Authority, the Ag Water Management. Under that contract is the AIEP, the Ag Irrigation work. RCPP builds off that, so we need to have both. So our period of performance will end at this fiscal year. Typically, we would get a 2-year extension. That's not going to happen now. You indicated that they were going to let out a new RFP for the Ag Water Management Program. So RCPP hinges on that. So I don't know, but there's 2 questions. How do we respond to a joint proposal for the Ag Water Management contract? Kelly had said that she won't provide 2 contracts. So we have to figure that out. We have a little time on that, but not much because that's supposed to be, I think you said, Kelly said that was coming out any day. I haven't seen it yet. And so our RCPP, which is the NRCS one, that needs to get going. I'm missing my first deadline, which is in sometime here in April to submit for producers to get access to those funds.
I'm confused. So,
I'm sorry. I
And
know
our-
I'm
this
so
is
lost.
hard, but-
yeah, because on the one hand, if you have obligations under an existing contract, because you're saying I'm already late in getting things out, sounds like there's already existing contract that is in place that
Yes.
needs to be, that is, so,
That's what I thought. And I thought
So-
at our last meeting, the existing contract, we were willing to let you move forward with it in our area. Because the other option if you can't do it, we will do it and we will do it. We'll find our own money I don't want folks to miss out on RCCP because they can't, because you couldn't do a water audit. And let's get the water audits done by you between now until the time we get it, the next 3 months or 2 months
mhm.
in order to get this thing done. That was my understanding.
And
when I
then we
walked out
should,
of the room.
and then we should make that one of the attachments with all of the background documentation, even though it's already in place and probably doesn't quote unquote need the agreement.
So for now, at least until the fiscal year, I can move forward with RCPP outside of- in those 2.5 districts that are outside of my.
Because you have an let me ask some questions. You have an existing RCCP signed agreement
Correct,
that expires in 26.
correct.
Okay, so yes, and in the area of Valley Center and the other one where our district overlaps that water district, at the last meeting, we said we were okay. We acquiesced, and actually those were my words, we
Yeah.
acquiesced, get the work done because we don't want their constituents to suffer not getting an opportunity to get these funds. That was my position. And that was stepping, to be quite honest, outside of the authority sort of, I'm walking a thin line with my board. And I'm willing to go back and sell it to them. So just to let you know, yes, they're okay. Any further agreements, my understanding, we're gonna put on hold until this got resolved. And that means any other agreements, now I'm hearing a large landscape agreement.
No,
and
there's
some-
no agreement
okay.
there. That's an RFP.
Okay, but-
Sorry, an RFP. So that's,
Okay,
and too many acronyms, I understand, but let me just clarify. So I can move forward with RCPP, but you said last time for a designated period of time.
yes.
That contract goes through 2026.
And I'm willing to give, how long do you think it's gonna take us to get the?
Yeah, he's willing to acquiesce until we get together and formalize this MOU.
And we said.
And
that
then
we-
the rules of the game
That's what I
change at
thought.
that
So,
point.
so I have preliminary approval. Once this, our MOU is done, then I can have full approval for RCPP.
Well, I think the anticipation would be that RCPP would be would be an agreement incorporated into this.
Correct.
And probably the other thing that agencies, all three of you ought to do is if there's any other existing ongoing agreements where you're in each other's districts, we should memorialize those somehow into this. With this then as the guiding document for moving forward on any contracts that aren't actually entered or grants not actually issued.
Like the CDFA planning grant, for example.
Well, so the only other one is the Ag Water Management Program, which will be ending this fiscal year in some capacity.
But we're gonna get this, I think the goal is to get this done so that there can be a coordinated application.
Yes.
I mean, the goal was to beat the deadline of this June 23 of this whole
Yes.
one that's
Yeah,
about to be
that's why I-
released. And so if we can get moving on that,
Yeah.
That was-
then come,
Yeah, it's
yeah,
not gonna take.
yeah, I think we
particularly
can.
long. I
Yeah,
think
we'll
we've
get it
got-
And that was my.
that was the scope and
That was my
target.
understanding was the deadline is this application period. We're gonna get this resolved and this will be the first one where we start with a new project and fresh. And you're right, we do have to go back and capture all the existing work that is currently open
Right.
and being worked on, either through agreement or not agreement, needs to come to the table and be laid out and discussed.
That's what we're doing.
Well,
There's two.
And I think if you can provide that to me, I think that makes sense to
Yeah.
incorporate something like that into the recitals, whereas
Yeah,
there's already
yeah,
this agreement and this
yeah.
activity is going on and this is meant to,
That's great.
Yeah, that
so
would be very helpful.
Yeah. that's kind of how I would envision it. So go ahead and send me that and I'll share it with Stephen because I don't see any reason.
Okay.
Perfect.
San Diego County Water Authority is very happy that we're starting to get along.
Yeah, yeah.
Good. It should benefit the region really to have a way to address these.
So I'll send you
Coordinated manner.
that large landscape on RFP when I get home.
Okay.
And if you'll just take a quick look at it, just mainly look at section 4, because I would imagine, much like us, the rest of it's not going to be a good fit for you. I mean, take a look at it, but it's June the 17th.
Of
Okay.
April?
Yes.
Okay, so that,
This is just a small, this is just a
I'm
small.
I
sorry,
understand that, but I'm
not-
just saying-
not I only gave on the one.
right.
This other one, you want to
So-
go for it on your own and you can do it in your area, it's fine, but I'm not opening up the table again to anything else. I'm just being upfront. This is important. If this is a really small one, we'll catch it later.
Well, it's actually a very large
Well,
contract, but
Then let's get this done quicker. I mean, seriously, that's the motivation. We need, if we want to pursue this, the motivation is, let's get it done so we can get this larger one done for you.
I got to be fair. I thought that was the expectation when we all left that meeting, is that they acquiesced on the program that Gary and Valley Center highlighted. Go do that work, keep those services and programs moving. And the goal was to get every other program outside of that
on
Under the agreement.
under the agreement.
So
sounds good.
And we don't have to have a perfect agreement. We can work and we can always improve the agreement as it goes.
Sure.
So we can build on this agreement as the timeline moves forward.
And that's,
We just
we
need to
need
get a
board
working
approval, yeah.
agreement that
Yes.
you and I can live with and our
Yeah.
clients can live with.
Okay.
So our next board meeting is next Wednesday, April 12th. In order for us to have board approval,
We'd have to
put it
have
before the board, we need it by tomorrow,
Thanks, Frank.
right?
Need what?
This is a MOU revision.
well, we can also call for a special meeting,
That's true.
you know, and I
Yeah, it's not gonna get.
I have this,
That's why.
I have the support from the board
Just being honest.
Yeah,
that
That would
if,
be
we need to get this resolved, they will come together in a location now that we can't do virtual anymore. So, yeah,
Yeah.
we'll make it happen at least from.
I mean,
the university side.
I think it makes sense if we all work diligently that if you can come to some terms on what you think and begin to prepare, you know, the bid that you would submit or whoever would submit or the combination of you, but I think we're just gonna need to kind of work at risk here because if we don't have the agreement, I don't hear Greater San Diego. I think I hear them keeping our feet to the fire. And we're just gonna have to live with it, which is sad for, I think, the region, but maybe just motivation to get done and think about calling a special meeting.
We should be able to get this done,
Yeah.
just so you know, the
Yeah.
lawyers make it a priority.
And I'm sure you will, but I'm gonna I drew the line last time
Yeah.
before this was,
And I
I
would
was
just-
aware of
Well, this
this.
just came out. so
I
this
understand.
became a new- Yeah.
So now this is motivation for us to get moving and in the
And I
right
guess I would
direction.
suggest to all three, you know, think about when a special meeting could happen if you don't have one within the time frame we need.
Well, we're kind of bleeding into the next item, so
There
I'm
we
gonna
go,
stop you
sorry.
right there.
There we go.
We're gonna have a hard stop here in the
I was
next
just
couple of minutes.
transitioning you.
Thank you, appreciate that. Real quick, Tammy, Erica, any members of the public that have submitted pre-meeting or during the live deliberation here for item 5B?
No comments.
No idea.
Okay. That'll close item 5B. We'll move on to 5C, which is our future meeting locations, dates and times, which I think gets into what you were saying, Christina, is let's put together a little timeline really quickly on what our next steps here. I think at our last meeting, we already had a tentative date for April 26th
Mhm,
at 2 p.m.
mhm.
It sounds like there might be a little more legal workings for the document to be put in place before you guys go to your actual boards of this month. So let me put it on the table to you of what's more realistic here. Because it seems to be like a short turnaround to get something advised or amended before you guys go back to your boards. Because that was the original intent at our last meeting.
Mhm.
So we have a meeting for this group to convene again, April 26th,
Mhm.
2 p.m.
Right.
Here.
here.
And the idea was our board would already
I will.
have something.
Bye, guys. Thank you.
Thanks.
Bye.
Do we want to use that time frame between now and then for you guys to
I think what we're gonna have to do is
put your legal
put our
minds
heads
together and
together to
confer?
try to come up with something that could be presented to all three boards.
That'd be great, because you have this is a pretty good document.
It's pretty
already. I mean,
close.
it's just
We-
a good
I
thing to
can
take
meet that
out.
deadline.
I think so.
I'm thinking it gives you guys 3 weeks
That's
to
plenty
put
of
together
time.
a document. We come back August or April 26th to discuss it, and hopefully it's in kind of more of a final format.
Well, hopefully it's been approved by
what
boards
time-
because
Oh, you want-
the only way to apply for that grant, if that's,
That's a quick timeline.
And I
That's
think you checked it last time. to make sure that
when you, I mean, you guys all said you meet mid-April.
yeah.
Unless you guys can do your work in 2 days.
I'm gonna have my board preliminary, at least approve the draft,
Okay,
because we have our meeting on the 19th.
okay, well, we'll have,
Yes.
we'll have a subsequent draft, I think, before the 19th.
Absolutely.
Yeah,
Great.
but I
So you'll-
mean, the thing is, that means nobody's submitting on the 17th.
When's your next
Yeah.
board meeting, Amy?
Okay,
Next
so we're
week, a
letting
week
that
from
go.
today.
Yeah, I guess.
So
Okay, all right,
13th.
well, then that's not much pressure.
So can I even have a conversation with Ann about the
You
large
can
landscape?
talk
or we
about it
just
all
wanna
you
take
want,
it
but
totally off the
nobody's
table?
gonna
I just
apply.
don't see how that you have enough time to get that on your agenda.
Got it.
How much is it?
Well, it's gonna be a $12 million contract when they
Well, I
have
don't
all
think
the
you want to
funding.
forego that.
I know, I don't know
No,
why.
And that won't come
See,
to
I
us.
understand
It's a
that's
small
right.
part.
Short order.
It's
just-
basically the funding for the water.
Well, it can be turned around shorter.
Yeah,
Let's get it turned, let's get it turned
That's what I was
around.
saying is,
I mean, let's get it turned around.
Well, we could just make that a separate thing, because Ann needs to still look at it and see if there's something she even wants to do. Basically, it's just the waterscape program.
Well,
It creates funding.
I tell you what, you guys have a conversation.
yeah,
My position still stands.
Okay.
And from the perspective, if the attorneys get this done quicker and get it out and we approve it as boards, then we've done the mission of LAFCO. There's no reason to come back. So if the attorneys can take care of this and get it turned around and we get it approved, and I would suggest Darcy and Ann and Amy, who's on the line, the three of you get together on this $12 million potential, build out whatever it is you think you're gonna need. By the time you're done with that, this should be done, and it's gonna come to us with our legal counsel, and I know my board isn't gonna sit there, we're not attorneys, that's why we hire Steve, so we're gonna endorse what he puts before us and with his recommendation.
Amy, do you have your hand up?
Yes, I do. So I just wanted to state that our board meets on the 13th, like as Andy said, we can at the time of the meeting add if there's a final close to final document, I can add it for approval at the time of the meeting. I can do an agenda in addition to the agenda, but I would need, our attorney would have to review it, and what I can do is add it to the agenda and say, for the board to approve the administrator to sign it with concurrence of our attorney. So that way, that saves time. Otherwise, I can do a special meeting anytime.
Amy, this is Don with Greater. You know what, talking to Ann, we can do the same thing with this. We can go with whatever is the most current draft and can submit for our next board meeting and simply say that the board supports based off of Ann and Steve's concurrence, and then that authorization will allow her to execute. So if we all do that,
would be helpful.
if we all do that, there's no reason why you shouldn't be able to meet your deadline.
Okay, yeah.
When's your board meeting, your next one?
The 12th. Next
Oh,
Wednesday.
And then when are you,
Before
when's
mine.
yours?
The
'Cause you'll
12th.
need the special.
It's either the Wednesday.
12th, 13th, and 19th.
Yeah, but you'll need a special.
Whatever that Wednesday is, I think it's the 19th.
So-
Are you saying,
Yes, I'll have to.
Yeah,
are you guys saying if you guys all approve this, then
We're done.
okay,
As far as I'm concerned,
okay.
we met the objective, which was to find a way to
work together.
resolve the violation of government code
Mhm.
56133.
Well, Steve, Christine, if you can get this done in 3 days, I will applaud you very highly.
thinking by, well, I mean, a piece of that relies on the bodies getting some information back to us about the pre-application
Process.
phase that you want incorporated in this agreement. So,
Oh,
So to
okay,
the
let's talk
extent,
about
you
that
know-
really quickly then. So,
Well, let's talk offline. Let's
yeah,
talk
I think
offline
talk
for that.
offline. I think the
Okay.
three of you, executive directors, should talk about like just a step-by-step so that we can incorporate what
Okay.
needs to into that.
I'll throw together the starting point, send it to you and
Sounds good.
Amy,
Okay,
and you guys can take a
Well-
look at that.
Sounds
and-
good.
we'll leave it at that. You guys are gonna get this document refreshed as quickly as possible, take it to your boards 12th, 13th, and 19th. If that's achievable, then our work is done. If not, we have a tentative date, April 26th, 2 p.m. to continue our discussion. Okay, that will conclude item 5C. I will pass on 5D, respect all of you, but just like to adjourn this meeting today at 2:34. So thank you for everybody for your participation.
Thank you.
Thank you.
Thank you.